Lord Sales will hand down this judgment.
This case raises an issue about the law in relation to the protection of the environment and a separate issue about the operation and effect of a grant of outline planning permission for development. The appellant is a property developer which proposes to carry out a major residential development on land near the Somerset levels, which is a site of environmental significance. It has been designated as a protected site under what is called the Ramsar Convention. This is an international convention dealing with protection of the environment which has not been incorporated into domestic law. In December 2015, the local council planning authority granted the appellant outline planning permission for the development. This provided for the development to proceed in a number of stages, subject to conditions requiring approval for certain aspects of the development at later stages, known as reserved matters. The Conservation of Habitats and Species Regulations 2017, which I will call the Habitats Regulations, implemented the EU's Habitats Directive in domestic law. Unlike the Ramsar Convention, the Habitats Regulations are domestic law, which sets out protections for certain other sites of environmental significance. By contrast, the protection for Ramsar sites is set out not in law, but in national planning policy, which provides that as a matter of policy, listed Ramsar sites, such as the Somerset levels, should be given the same protection as sites protected under the Habitats Regulations. The Habitats Regulations continue to have effect post-Brexit. Where they apply to a protected site, they require that what is called an appropriate assessment should be made before a development proposal, which might have a detrimental impact on the site, is allowed to proceed. An appropriate assessment may reveal ways in which environmental damage can be avoided or mitigated. Regulation 63(1) of the Habitats Regulations provides that for a site protected by those regulations, a planning authority should carry out an appropriate assessment before deciding to give any consent, permission, or other authorization for a plan or project which is likely to have a significant effect on the site. In June 2020, the appellant was granted reserved matters approval for Phase 3 of the development, which comprised 190 dwellings. That reserved matters approval was itself made subject to subconditions requiring approval for certain aspects of the development to be given at a later stage. Those aspects related to matters which had nothing to do with protection of the Somerset Levels Ramsar site nearby. At this stage, no environmental threat to that site from the development had been identified. However, later in 2020, Natural England published new scientific advice in relation to the protection of the Ramsar site. This identified that the site was at risk from the accumulation of excessive nutrients in water as a result of enrichment by phosphates linked to development, and it advised that before determining a planning application that may give rise to additional phosphates within the catchment for the Ramsar site, competent authorities should undertake a Habitats Regulations assessment. In June 2021, the appellant applied to the Council for approval under the subconditions imposed on the reserved matters approval for Phase 3. The Council withheld approval on the basis that an appropriate assessment under the Habitats Regulations was required before the approval could be granted. The Council adopted this position in reliance on the 2020 advice by Natural England and the statement of national policy in relation to Ramsar sites that they should have the same protection as sites subject to the regulations. The appellant's appeal against the Council's decision was heard by a planning inspector who dismissed it. The appellant unsuccessfully challenged the inspector's decision in the High Court. The appellant appealed to the Court of Appeal, which also dismissed the appeal. The appellant now appeals to the Supreme Court. Two issues arise. The first is concerned with the interpretation of Regulation 63(1) of the Habitats Regulations. The appellant argues that, read in context, this provision does not cover the grant of approval for reserved matters in relation to an outline planning permission, or for approval of matters covered by subconditions relating to those reserved matters. The appellant says that any appropriate assessment for a site protected by the regulations had to be carried out at the time when outline planning permission was granted and could not be carried out later than that. Therefore, the appellant's argument runs, the same applies in relation to a Ramsar site, such as the Somerset levels, because of the cross-reference to the regulations in the Statement of National Policy. The Court rejects this argument. It holds that, having regard to the purpose of the habitats regulations to provide protection for the environment and the natural meaning of the wording of Regulation 63, that provision is clearly intended to apply in a case like this. The scientific advice from Natural England emerged late on in the phased development, but indicates clearly that the development potentially represents a threat to the environmental integrity of the protected site. The last remaining authorization before the development can be implemented is that required for the approval in relation to the subconditions attached to the reserved matters approval. Once that approval is given, the development will proceed. In those circumstances, the only way the objects of the habitats regulations could be fulfilled, if they had applied to the site, would have been for an appropriate assessment to be carried out before that authorization was given. The language of Regulation 63.1 is appropriate to cover this situation, since this approval falls within the words "other authorization" in that provision. The second issue which arises is of a completely different nature. This issue is concerned with the effect of the grant of outline planning permission. An outline planning permission is planning permission granted subject to conditions requiring later approval of certain matters. The courts below held that, in deciding whether to grant such approval, the planning authority was required to follow and apply the national planning policy, which said that the Somerset Levels Ramsar site should be protected in the same way as a site covered by the habitats regulations, so that an appropriate assessment was required. However, this court holds that this was an error. When conditional planning permission is granted, the meaning of the conditions is determined at the time of the grant, and when subconditions are imposed, they have to fall within the scope of the main conditions. In this way, a developer can know for sure, when it obtains conditional planning permission, what it needs to do in order to be allowed to proceed with its development, and can understand what risks it is taking on, so as to enable it to decide whether to invest in getting the development ready to proceed. In the present case, the conditions attached to the outline planning permission made no reference to the need to protect the Somerset Levels Ramsar site. Therefore, the Council was not entitled to introduce that as a new variable or risk factor late in the development process in the way it did. Under planning law, the appellant's rights in relation to the conditions were fixed when the conditions were imposed according to their proper interpretation. The Council was not entitled to rely on a statement of planning policy to change that state of affairs and introduce a new risk factor which was not referred to in the conditions. There is a fundamental difference between a statement of policy and a legal rule in legislation such as the habitats regulations. A statement of policy cannot alter the rights of a developer under the planning legislation in relation to a grant of outline planning permission. A rule introduced in later legislation, such as the habitats regulations, can do that, but those regulations do not apply to a Ramsar site. The error of the courts below was to treat national policy as if it was binding legislation, overlooking the critical difference between the two. The appellant's appeal is therefore allowed on the basis of this second issue. If the appellant has satisfied the conditions and subconditions attached to the outline planning permission, according to their proper interpretation, it has the right under planning legislation to proceed with the development for which permission has been granted.